And today we are going to have a very interesting discussion, and I have some very simple questions that I'm asking, and I introduce you to them. First of all, there is a controversial CI 73. I'm asking the question, is it a matter that government is in an indecent haste to create 45 new constituencies, or is it a matter of a genuine quest to deepen decentralization for local developments? Question number 2. Is President John Mahama, an imposition on the NDC, set to bring destructive internal conflict and disunity in the party? Is a question being asked by myself, but this is a quotation from Martin ABK Amido, and that is his question. Question number 3. The NPP says, okay, call it a question. The NPP says President Mahama told the nation in his broadcast this week that, quote, "I am also a nice guy, so vote for me." Well, they don't believe in his peace and civility politics sermon, and so have been labeling him a corrupt and incompetent guy, together with his vice president, who offer nothing new. And very finally, do you still want to know how your president died? Inquest or no inquest? These are the questions that my guest will be discussing or answering. Today, I've already introduced the topics to you. We'll start first with Martin Amidu's concerns about the Constitution and the NDC's Constitution as well. But he's more concerned about what he says it's a possibility for disruptive internal conflict and disunity in the NDC because of what he calls imposition of a flag bearer on the party. My guests are seated, and I have here Nana Akomia. He is Communications Director of the Opposition New Patriotic Party. Felix Kwachi Fosu is Government Communications Team member. Will be joined shortly by Alhaji Yunus Afuseni. He's Deputy Energy Minister, and he is a man who had a hand in the drafting of the NDC's constitution. To my extreme right is Kweku Bako Jr. He's Managing Editor of the New Crusading Guide newspaper. Gentlemen, good morning and welcome to the show.
Good morning.
All right, so I'll start first with you, Felix Kwachi Ofosu. Now, the Honorable former Attorney General has serious concerns with the manner in which you are proceeding with your flag bearer. He says that what you have done and waiting for an acclamation of President John Mahama, when is it? Is it August? Sometime in August?
Yeah, I think
you're going to
it's
Kumasi?
Been brought to 30th August.
Okay, 30th of August. You're going to Kumasi simply to acclaim him as your presidential candidate. He says that reading the Constitution in tandem with the NDC's Constitution, you appear to be violating internal democracy, and you are calling for disruption and disunity.
Well, good morning to your viewers, Samson. Again, Mr. Martin Amidu's position is inexplicable when set against the objective reality on the ground. That is, if one makes reference to the NDC Constitution, which, for all intents and purposes, regulates the activities of the party. And being a lawyer, and a senior one at that, and also being a senior member of the party, I would have imagined that he would read the Constitution fully and make comments or make statements or adopt positions that reflect the position of the Constitution. In this instance, I think that he's spoken out of 10.
Comprehensive analysis of the situation.
Yes, I've read.
He's not done justice to it.
At all. I don't think that he's done justice to the issue at all. Because you see, the Constitution is in black and white. Indeed, people have argued that sometimes we require lawyers to interpret these things. But the NDC Constitution is so simple and straightforward that one does not need to be a lawyer to understand what it says. Now, the NDC as a party, and indeed Ghana, has been hit by an unprecedented tragedy. Now, unfortunately for us, our Constitution does not or the framers of the Constitution did not envisage such a situation, and therefore did not make specific provisions to cover it. Now, the issues that Mr. Martin Amidu raises are as follows. He says that, first of all, the statement or the statement issued by Mr. Johnson Asidun Ketia, the General Secretary of the NDC, to the effect that President Mahama has become the leader of the NDC was unconstitutional and undemocratic. Again, I find it difficult to appreciate that point because our Constitution is clear. It says that this Article 26(1), that is a relevant provision that takes care of national offices. It says that the President of the Republic, who is a member of the party, is a leader of the party when it is in government. I get the sense that Mr. Martin Amidu is saying that simply because His Excellency John Dramani Mahama was not elected to the position of president, then he cannot assume this role. But the Constitution does not say that it is an elected president. The Constitution says that it is a president who is a member of the party that becomes the leader of the party. Again, it goes on to say that where a sitting president is not a member of the party, when a flag bearer is elected, he assumes the role of a leader. This is clear-cut. It is beyond any debate. Anybody who can read and write would understand this point. So, Mr. Asidun Ketia did not violate any provision of the NDC Constitution, neither did he violate any provision of the National Constitution when he issued that statement. A vacuum had been created following the untimely and tragic demise of President Mills. It was necessary to fill that vacuum, and that is why immediately he put it out. Some may have argued that automatically this provision would have kicked in, so perhaps the statement was not necessary. But it was important to resolve any confusion, any doubts that may have arisen because of the situation that was created. The second leg of Mr. Amidu's argument is that by endorsing President Mahama as the candidate of the NDC and putting together a Congress to acclaim him, some provision of the NDC Constitution has been violated. Again, he is unable to provide exactly what provision has been violated. Now, the facts are these. The election of a flag bearer is catered for in our Constitution. Now, the Constitution says that when we are in power, that is when we have a president who is running this country and we want to elect a flag bearer, we do it 1 year before the general elections. When we are out of power, in other words, when we are in opposition, we do it 2 years before the general election. Now, those provisions cater for normal times. Unfortunately, the Constitution does not cater for times that you can describe as not normal or abnormal. And therefore, if we were to go through the process of electing a flag bearer using provisions contained in this Constitution that cover normal times, we will be violating the Constitution because we cannot meet that 1 year deadline or that 1 year time frame that is provided for by the Constitution, because we would have barely 4 months to the election. Again, because this thing is not catered for, the relevant provision of the Constitution that kicks in is Article 50, which seizes the National Executive Committee with residual powers to make regulations to resolve the situation that is not catered for by the Constitution. I'm going to read it. That's Article 50. It says, where on any party matter, there is no provision in this Constitution which deals with that matter, the National Executive Committee shall, by regulations, provide for that matter to be dealt with. So the National Executive Committee met a day after President Mills' unfortunate demise and decided that this is how they were going to regulate the situation which is not catered for by the Constitution. You must understand that by going through an acclamation process, democratic principle is being followed. Because essentially it is a vote. If we go to Kumasi, and the delegates refuse or fail to acclaim President Mahama, it means that his candidacy will be invalid. Or, in other words, he would not have been accepted as a candidate of the NDC, and therefore we may have to find another way of getting a candidate. So this is very, very clear. No provision of this Constitution has been violated. Again, it must be understood that sometimes common sense is also necessary in times like this. In September, I stand to be corrected, in September, political parties are expected to present their flag bearers to pick nomination forms and submit them at the Electoral Commission. So time is also of the essence. Assuming that even the Constitution that we have does not cater for a situation like this, common sense dictates that if you have a president, somebody who has assumed the position of president, somebody who was on the ticket of the previous candidate of the election, someone who was nominated as vice presidential candidate to the candidate who was elected popularly at Sunyani, you do not rock the boat. You do not set the cat among the pigeons at a time when you have less than a month to go through these motions and present a candidate? Somebody who has been marketed, somebody who everybody knows. Why do you shove him aside and go and pick another person? And that is just a common sense argument.
Well,
in any event,
he certainly feels that something has been done wrongly, and like you say, common sense ought to apply. But for him, I feel that he feels that if in a situation where you have laws or regulations that bind you, common sense should not be said to take precedence over your laws. Now, he says also that, and I quote him, he says that it would appear that those in control of the NDC for the time being were bent on excluding other bona fide members of the party who may wish to lay democratic claims to who becomes the next flag bearer of the party by excluding them, even before the mortal remains of the demised president were interred.
First of all, the common sense argument was just to tell you that even if no provision at all has been made for this, and the National Executive Committee did not have the powers to do what they have done, common sense would mean that we do something as quickly as possible. And the most obvious choice we would have would be President Mahama. But that is if nothing existed to back it. But
you think that you have shut the doors to others who may have wanted to contest it?
No, Samson, I have indicated to you that what the National Executive Committee did was backed by law. First, by announcing that President Mahama had assumed the role of leader of the NDC. It was backed by the Constitution. Again, Article 50 makes it possible for them to do what they did. Nobody has been excluded. Because for the argument, those making the argument that the process ought to have been open for others to enter, that would have become valid if we were in normal times. If we were in normal times, the National Executive Committee cannot do what they have done because they will not have the power to do it. The National Executive Committee has done what it has done because it was not catered for by the Constitution. Yet they have been given powers to do something about events, instances, scenarios that are not catered for by this Constitution. In arriving at this decision, they met the entire National Executive that has ministers, that has specified persons who form a membership of that committee. Those members also represent constituencies across the country. Mind you, we have regional chairmen, we have constituency executive, we have national executive, council of elders, and what have you. We also have a legal team that looks at these matters and advise NEC accordingly. So it cannot be argued that the National Executive Committee has done anything out of the ordinary. Right. Another point, the final point, before I go, is that Mr. Martin Amidu has sought to compare the current situation to the Swedo Declaration. And indeed, I found that a bit strange. Because Mr. Martin Amidu, as we all know, was one of the biggest beneficiaries of the Swedo Declaration. How is it that if he feels that that particular declaration was illegal and flouted the NDC Constitution and National Constitution, how is it that he accepted gleefully to become vice presidential candidate of President Atamos? In other words, he was willing to participate in illegality to the extent that he benefited from it personally. He was Deputy Attorney General. He had a duty to advise governments on the legality or otherwise of the step that was being taken. He, as a senior cadre and a senior member of the party, also had responsibility to advise against it. He didn't raise any objection in any quarter whatsoever. Yet, because this time he is not benefiting from it, he is suddenly seen that something illegal has gone on. But I'm saying that nothing illegal has gone on. And therefore, I think that Mr. Martin Amidu has to reconcile the two positions. He must explain to Ghanaians why he accepted to be part of a so-called illegality in the year 2000. But he is quick to come and condemn what has been done and what, by every account, is legal.
Is it you're suggesting that a wrong that was not contested earlier, when repeated, should not be contested
but it was
again?
Not, you see, when the person making the claims was a direct beneficiary and saw nothing wrong with that deal, he cannot come 10 years down the line, 10, 12 years down the line and claim that something that has been done, which is legal in any event, is illegal. It questions his own commitment to principle and fairness. Welcome
to the show, Deputy Energy Minister Alhaji Yunus Hussaini. We'll come to you shortly because you are part of the architects of the NDC Constitution. But I'd like to bring Nana Kumia on at this point. Nana, I don't know, do you agree with Martin Amidu that it appears that something wrong is being done, particularly to the extent that the door is being shut to potential presidential candidates for the NDC?
Thank you, Samson. Let me say good morning to your listeners and to your viewers and to my co-panelists, particularly my brother here, the Deputy Minister, who I haven't seen for some time. Now, I agree perfectly with Martin Amidu. And I've listening to Mr. Kwachi to try and understand the argument against Martin Amidu. And it's been difficult for me to understand what is being put forth against Martin Amidu. I also realized that Mr. Kwachi made a lot of insinuations and innuendos that go to the Mr. Amidu's logic and his thinking. I don't think we need that. If you disagree with the gentleman, you state why you disagree. There's no need to make insinuations and innuendos about Martin Amidu's.
I put forward the arguments based on the law,
yeah,
as
but
I understand it.
You use words
I faulted his argument. It is legitimate to do that.
You didn't. You said that the thing is written in black and white.
Exactly, but so that's why I'm surprised.
Is that he should know better.
Exactly,
don't
but he
need
should know better than make the argument that he made, because it does not exist as far as the law governing the NDC is concerned.
He has a view. You have a contrary view. That's it. You state your view like he stated his view.
Okay, so proceed with your point. You think that he has a valid contention?
He didn't make insinuations and innuendos against anybody. He just stated his view. Now, I side with Mr. Amidu 100%. And I have not.
Welcome back. This is Newsfile on Joy 99.7 FM. You're also watching us on your multi-TV Joy News channel. I want to sincerely apologize for the disruption that we encountered in the course of the program. Thank God we are back to normal. And I would quickly want to rather get Nana Komia to sort of summarize his point, and then we'll move on to Honorable Yunus Hussaini. Now, for me, I said that from what I picked from your submission, essentially was that if it had happened to the NPP, you would have done things differently. You would have gone to Congress and had an elections. You think that would have been a feasible thing to do?
Absolutely, because really, that is what the Constitution calls for. The Constitution has made prescription or provision on how you select a flag bearer. All the constitutions have it. There is a vacancy for the position of a flag bearer. You are actually going to have a contest, an election, because you are going to go to the General Assembly of the NDC on the 30th or so, or the 1st of September. So you are actually going to go. August. You are actually going to go before the NDC electorate.
Do I hear you say that your constitution makes provision for such a special circumstance as has befallen the NDC?
The constitution makes provision for the selection of a flag bearer.
Generally.
That's it.
Just as you have in the NDC.
That's as you have in the NDC. So it is not a situation where the constitution has not made provision for. And indeed, they are following the provisions. It's just that they're not following it full scale. By going to a Congress to get a selection of a flag bearer. But the different thing they've done that Martin Amidu has a problem against, of which I support him, is that they have excluded other people from putting themselves before the Congress to be considered for election. And there's no excuse for it. If you believe that President John Mahama is your best candidate at this time and all of that, you negotiate with everybody and open it. If anybody wants to come, you can put the same arguments to the person. If the person buys them, if the person is a real patriot, the person will back down. But you don't, by fiat, like the NEC, the National Executive Committee did, exclude everybody and say that we will still have the Congress, we will still have the election, but we are only going to consider one person. What is the point of that? Is that going in tune with democratic principles and accountability? My conclusion is that you are not even doing a service to John Mahama, because if he goes through this as a sole candidate, there would always be this perception championed by Martin Amidu and others that he didn't go through a fair contest. The NDC doesn't need to inflict this wound on his own self.
Honorable Yunus Hussaini, Barkare Salah once again, and I ask the question again that the contention is that your interpretation of your own constitution, which you were part of the architect, is not in consonance with that of the 1992 Constitution,
well, that
which enjoins you to practice, to have democratic principles guiding what you do.
That's far from it. I mean, clearly, the NDC constitution is in consonance with Article 55 of the Constitution that enjoins all political parties to run their affairs along democratic principles. And our constitution was submitted to the Electoral Commission, and they received and endorsed it as being consistent with Article 55 of the Constitution. Now, yes, I listened to Nana Kumia, and all constitutions of political parties will necessarily provide for how a flag bearer, indeed any office holder of the party, is elected. All constitutions. But not all constitutions will envisage that their flag bearer or president or presidential candidate will die in office. This is the situation that has confronted us. And we all know that in reading the Constitution, you don't pick separate provisions and interpret them. You have to interpret the whole Constitution as a whole document. Martin Amidu's argument is at best, with the greatest respect, misplaced, irrelevant, and totally inconsequential to the processes that the National Executive Committee has adopted to select the flag bearer of the party. He hinges his argument on Article 26(2). Article 26(2), what does it talk about? Article 26 is entitled National Officers. Article 26 says National Chairman or Co-Chairman and National Vice Chairman. The intendment of that provision is to provide for the National Chairman of the party. But in that provision, we solve a problem. That was the problem of the NDC since 1992, when we vested the founder and leader of the party in one person. So, when we had an opportunity to review our constitution, we separated the founder, which is a ceremonial title conferred on former President Rawlings, and the leader. He reads Article 22 and says that Article 22 says that where a certain president is not elected a flag bearer, a person elected as flag bearer of the party at any time prior to election is the leader of the party. Granted, that's the provision of the Constitution. But what comes before it? The chairman of the party, when the party is in opposition and until a flag bearer is elected, is the leader of the party. So Article 26 talks about the national chairman or co-chairman, and then what role they play in between elections when the NDC is in opposition.
Presiding over Congress.
Congress. They become the leader. In the event that a flag bearer is elected, when NDC is not in power, the flag bearer becomes the leader of the party. So Article 26 is inconsequential to determining whether or not John Mahama was validly nominated as the NDC flag bearer. The relevant provision, and he goes to Article 44. And again, the Constitution enjoins us, in the interpretation of the Constitution, it enjoins us to read the Constitution as a whole. Article 44 says election of a presidential candidate. And I'm going to read it verbatim for the understanding of your listeners who might not have the NDC Constitution at hand. Article 44A says the date and venue for the election of the presidential candidate shall be decided by the National Executive Committee, provided that such an election shall take place at least 12 months before a national election date, in the case where the party is in power, and at least 24 months in the case where the party is outside
of government.
Clearly meaning that when the party is in power, you can do the elections within the last 1 year. It should be 1 year before national elections. Shall is used here. Shall take place. Mandatory. Now, President Mills died on 24th July 2012. Clearly, less than 1 year before the national elections. Matamido relies on the election of a presidential candidate as basis, combining it with Article 26 as basis for saying that that was an imposition. It clearly ignores the mandate, the injunct, that if we're in power, or when we are in power, the presidential candidate must be elected at least 12 months. And when in the position, at least 24 months, 2 years. Now, so again, the president having died less than 1 year to national elections, Article 44 does not apply. So what happens? You come back to Article 23. Article 23 tells you clearly that a certain president or a presidential candidate of the NDC is a member of the National Executive Committee. That's what Article 23 tells you. And Article 47 will tell you how a vacancy created at any level within party structures in this country should be filled. And the most relevant provision is Article 44(1), which says any vacancy in any executive position at any level of the party may be filled by appointment.
Did you say Article 44(1)?
Article 47(1).
Okay.
Article 47(1), miscellaneous. Any vacancy in any executive positions at any level of the party may be filled by appointment as follows. 1, and the most relevant provision, 1, at the national level by the National Executive Committee. 23 clearly tells you what the National Executive Committee is constituted of. And the president or presidential candidate is a member of the National Executive Committee. His death creates a vacancy. Even if he were not president and he was presidential candidate, in which case he was. The two were now vested in one person because we are going to Sunyani to elect the late President Mills as our presidential candidate. And he was the sitting president. So the two were vested in one person. He was a member of the National Executive Committee. His death created a vacancy. That vacancy ought to be filled. Now, again, in our democratic transition, on that very 24th day of July 2012, the country rose to the occasion and swore in His Excellency John Dramani Mahama as President of the Republic. The President of the Republic by the NDC Constitution is a member, if he is a member of the party, is a member of the National Executive Committee. The National Executive just did what was reasonable, proper, in the circumstances. They had no choice. They didn't have a choice at all. Unless Honorable Martin Hamidu is saying that when one becomes a president, he ceases to be a member of the party until such membership is conferred on him. Because the party doesn't say that the president, if he's a member of the party, at the time that he becomes president, it just says if he's a member of the party.
If you can briefly address his concern also about you having shut the doors to potential candidates.
No, what the National Executive Committee have just done is simple. Now, having elected His Excellency, or elevated His Excellency, who was at all material times a member of the National Executive Committee as Vice President of the Republic. Just like His Excellency Emisa Kwesi Emisa Atta is a member of the National Executive Committee. They just simply elevated him to be the leader because I read to you the leadership of the party. As the leader of the party, they then nominated him as a flag bearer. Now, Article 50 and 22 of the Constitution. Article 50 deals with the residual powers of the National Executive Committee. Article 22 talks about Special Delegates Congress. Listen to what it says. Article 22, Special National Delegates Congress. The National Executive Committee may call a Special Delegates Congress at such notice, place, and date for such purposes for such purposes, that is the operational word, as it may think fit. So this is not the normal congresses every 2 years, no. So we have been hit by a tragic calamity. Our president departed in circumstances that all NDC members would have wished that he were with us, with his sterling qualities, to contest the elections. That is a calamity. That calamity raises issues of secession. Who steps into his shoes? The National Executive Committee, have, by powers invested in them by Article 47, have filled the vacancy. But Article 50 is residual power. We have no provision in the Constitution that says that when the president dies, the vice takes over. We have no provision. So that's the residual power. Combining the residual power with the Article 22 of the Constitution clearly means they have gotten a leader. This is the leader of the party.
That power vested in the National Executive Committee may not be contested. But the question is, why did you elect that path when you had the opportunity to also decide the other way, that we'll go to Congress and have elections?
Samson, there was no opportunity. I read to you Article 44 that talks about the election of a presidential candidate. We didn't have 1 year. Yeah. And mind you, I told you that that is a mandatory provision. You don't have 1 year. You see, unless, of course, you are going to give meaning to this Constitution by breaching the provisions of the Constitution.
All right. Thank you very much, the Honorable Deputy Energy Minister. I will now take Abdul Malik Kubako's inputs here.
Yeah, I've listened very carefully to especially my good brother Fuseni. He's making very sound, or apparently sound, legal points. I'm a layman, but I am going to ask some few questions so as to get a better understanding of this thing. I can see out there conflict, some tension between common sense, realpolitik on one side, and constitutionalism and legality on the other side. I think that Martin may have raised an interesting point that if it's properly interrogated dispassionately, without name callings and installs and those things, may help deepen our democratic practice for the future. Because it's true, the NDC is confronted with an extraordinary situation, and realpolitik called for some swift and certain things to be done. But they may have to look at this thing critically for the future, and for that matter, all parties in this contest. Because I've been reading their constitution. First point, the point my brother made about Article 47, which is the question of filling in vacancies. Something struck me when he was making his analysis summation. That is talking of filling any vacancies in any executive positions at any level of the party may be filled by appointment as follows. And I'm sure you were looking at one. At the national level by National Executive Committee. And in so doing, you linked it to, is it 26, where the presidential candidate is a member of the 23, is a member of the Executive Council. I'm a bit worried there. Why? Because, you see, in electing a flag bearer, presidential candidate, the mode is different. You use a different method, a different platform to elect the flag bearer. And he becomes a member of the Executive Committee by virtue of being a flag bearer. Is that not it?
Yeah.
Now, I don't see how, in terms of if you are looking at executive positions, it's not synonymous with the position of flag bearer. I think there's an extension. So I am not sure that this Article 47 and 26, the two articles, have anything to do with the matter Martin is raising. That's my candid opinion. As a layman, I think they are immaterial and irrelevant. They are inapplicable to the issue before us. That's my first submission. I may be wrong. You can come in and clarify.
Yes, which issue? There are two issues.
I haven't finished.
I just want to draw
No, please go. Go on.
You are talking about flag bearer. I'm just inviting you to look at Article 23, 23D And probably when you read it together with 2047, and then give us your view.
Now, if you can read it out,
Article,
that will help.
Article 23(1)(d) says that, first of all, Article 23 says National Executive Committee. Says there shall be a National Executive Committee which shall consist of the following. D, Vice President or Vice Presidential candidates. If he is a member of the party, candidate, it should not be candidates, candidate, if he's a member of the party. C says president or presidential candidate. So actually, a vice presidential candidate who is nominated by the flag bearer becomes a member of the
but I am saying that
Yes.
the two are inapplicable relative to the issue of flag bearer as to how flag bearers are elected at any time in your party's calendar. Whether a year before when you are in opposition, 2 years before when you are in opposition, or 1 year before when you are in government. What I'm saying is that in my little layman's view, I believe that Article 23 and 47, which is filling of vacancies, are inapplicable in this sense. That's the way I see it.
Okay.
I may be wrong,
Okay,
but that's the argument I'm making.
Okay.
Now, you see, and as I said, he's raised issues, that's Martin, which, if it's interrogated properly, may help all parties eventually in how we
Engineer their
our
constitutions.
constitutions, because of the element. Now, the issue of Article 50 of the party constitution, the NDC party constitution, that gives you residual powers. I've read that too carefully, and indeed, I ask myself, what is it that the executive committee did when they decided to operationalize or to invoke this article? They say you should make regulations, isn't it? Have you made the regulations?
Yes.
Where are the regulations?
The regulations are going to be distributed to members for the special delegate. You make regulations for the special delegates Congress.
But precisely, you make regulations. That is the understanding of my understanding of this thing. You make regulations. I have a feeling that the regulations ought to be published. The regulations ought to be circulated far ahead of that special delegates Congress.
Yes.
Indeed, it ought to be they have to have the benefit of different branches and organs of the party interrogating them.
Yeah.
This is part of democracy,
Yeah.
deepening the democratic
it,
thing.
yeah.
So you see, as at now, all we heard was that the National Executive Committee had met and had indicated that because the vice president had become president and because it's a member of the party, a provision in the constitution had automatically come into being. One is a leader.
Yeah.
I don't have much problems with that. Two, he's our proposed flag bearer for the Congress. We had decisions having been taken and outlawed, at least publicized. Now, for the first time, you are telling us that the regulations too have been made.
Yeah.
Now, we do not know, we don't have the benefit of the regulations.
Yeah.
As citizens, we are non-party members. But even as citizens, within the context of Article 55(5) of the National Constitution, that requires the political parties, their internal organization must be in tune with democracy. For the benefit of even the public, but even more so for your delegates and members. Some publicity of the regulations. What are those regulations? These regulations today, as we sit here, are cast in mystery. We do not know them. And that's not proper. And you see, and that only reinforces the point Martin is making. I believe, realistically and politically, in the situation in the NDC in which they find themselves, what they are doing eventually with John and Misa and all that, is what will happen. If it doesn't happen that way, it will be political suicide. But can you not do it in a way that comes with finesse and legality and constitutionality stamped on it, so that you leave little room for agitation? I think that, yes, I suspect there was an element of indecent haste in dealing with the situation. That was unnecessary. In my candid opinion, it was completely unnecessary. Because no matter what has happened and what is going to happen is what would have happened. That's my view. And it will make political sense to me. But how you went about it has created some problems. So if somebody raises the alarm now, and I hope the person is not talking of laying the basis for litigation, okay? I hope so, and he hasn't indicated that. And I'm not sure anybody out there who thinks of litigation will be helping anybody. That's my view. But I believe it's been stated, put on public record as a way of provoking us to look at some of these things in a more comprehensive manner. From that perspective, I see absolutely nothing wrong with what Martin Amidu has done. I think it's rather a plus for democratic interrogation of public issues of public interest.
At least there's a consensus that there's no luxury of time. This is an extraordinary situation requiring extraordinary solutions, and that is what you appear to have proffered. You're still on Newsfile on Joy 99.7 FM, and you're watching us also on TV, on multi-TV, my Joy News channel, we want to, I want to apologize again for the hitches that we encountered in the broadcast, but I understand that the technical people are working to ensure that we bring you this program flawlessly. Thank you very much, Felix. I think you can do just a minute, and then we'll move on to the controversial CI and constituency creation matter.
Yeah. Again, I disagree with Kweku when he says that there's nothing wrong with what Mr. Martin Amidu has done. You see, as a member of the party, and a senior one at that, he had every opportunity to lay his concerns before the leadership of the National Democratic Congress. He didn't need to go public with this issue, to the extent that he hasn't made any effort to bring these concerns before the leadership of the party. I think that he was stopped from going public. Doing that, in my view, amounts to a breach of party discipline. And it is important that in doing things within the NDC, and indeed any other party, we avert our minds to the need to use lay-down processes.
Are you inviting him for punishment?
No, I'm not saying that. No, I'm not saying that. I'm only expressing a view. And I think that it is much better to raise concerns within the party. Yeah. No stumbling block has been raised that prevents Mr. Martin Amidu from making these legal arguments before the leadership of the National Democratic Congress. So why did he choose to go public and insinuate that the party had done something that was illegal?
All right.
Honorable Inus Afuseni has clearly outlined the provisions as they are contained in this manifesto, and it is clear that Mr. Martin Amidu's arguments are completely misplaced and not in tandem with the NDC constitution.
He says they are misplaced and irrelevant. Gentlemen, I understand. Almost all of you want to make a point, but we have other substantive matters to deal with. So do 30 seconds.
Well, I believe Felix is looking at the form, not the substance.
Nana?
Yeah, Kweku read some interpretation on the NDC constitution about the flag bearer being a normal executive, because there's a different mode of selection and all of that.
Yeah. I think he did a solid analysis.
Yes, and regulations have not been published in all of that. That's what Martin Amidu is saying. You could avoid all of these issues about interpretation and all of that if you had just opened it up. True, you don't have 1 year, so you can't have 3 months, 6 months period. But you set a date for 30th or 1st September. You open the nominations. People have within that time to fulfill all the conditions.
All right.
And nobody will complain.
Which
but
you would have done anyway.
Is that you have by fiat, say you have the power to make, to deal with a vacancy in the national executive. And in exercising that power, you have decided that you would exclude everybody and offer just one person.
As far as they are concerned, they have exercised it legally and democratically.
And actually,
how can it be democratic when you
my brother Malik
everybody?
clearly understands the situation. I think that the problem was miscommunication. What the National Executive did, they did two things on that day. They did the feeling of the position, which Mr. Malik Okubaku says, no, there's no problem with that, because it appears to be a seamless transition.
Exactly. It appears to be an automatic one.
Exactly.
Yeah. And the second one is the nomination. Yes. It was a proposal at the National Executive Committee, but the newspapers and information coming out said nominated. We have proposed John Mahama for, and that is why the regulations are coming. Exactly. And I will take it from there.
So can other people offer themselves?
Good question.
Yes, when on the Congress grounds.
On the Congress grounds.
Okay,
Yes.
thank you very much, gentlemen. This is Newsfile.
that part of the
This is your most authoritative news analysis show. And I'll take one or two text messages, and we'll take a quick break. We'll return to the controversial CI that was withdrawn, replaced, and now hoping that Parliament will be recalled to sit to allow it to mature in 21 days. Is the government in indecent haste to do something for political convenience, or is a genuine quest to deepen decentralization for local development? Now, Mancha Bruce, he writes, verily, verily, I say unto you, members of Parliament, let us not seek the NDC or NPP answer, but the right answer. Let us not seek to fix the blame for the past. Let us accept our own responsibility for the future. For those who stand for nothing, fall for nothing. From Ata Imoro in Wellency, he writes, I totally agree with Mr. Amidu. If they, that is the NEC and NDC, claim the time is too short for them to open nominations for the flag bearer, why are they still pushing for the creation of new constituencies? However, I think it is not too late for Mr. Amidu to seek redress in court. Clement in UCC writes, the NDC is a democratic party by name and not reality. Rawlings was imposed, Mills was imposed, and now Mahama has been imposed on the party. Akbar writes, Martin Amidu is on point. The residual powers were wrongly applied by the NEC. Article 50 says, when the Constitution is silent on a matter, then residual powers can be applied. But the NDC Constitution isn't silent on the election of presidential candidate. Okay, Article 44 deals with how the election should be done if a presidential candidate dies or resigns in the NDC. If it is to be assumed that there is no flag bearer, and Article 44 ought to be activated and not Article 50. Abdul Rahman says it's obvious all is not well in the ruling party. Disunity, left, right, center, and they still pretend all is well, from founder to Martin Amidu and a host of other issues. It is in the light of this that the good people of Ghana must give Nana Addo the chance come December 7. Mukaila Damongo writes, Felix's submission. His Excellency John Mahama is not the best man to lead the NDC in 2012, but because of limited time, they are compelled to consider him. Did he say so? Alale Baba in Pusiga writes, Martin Amidu seems to know so much of the Constitution. Now that he is not part of government, he should give us a break. Now we go to the controversial CI, and the question I'm asking is whether or not government is in indecent haste to create the 45 new constituencies, or this is a genuine quest to deepen decentralization for local development. As you may well know by now, that CI 73 was withdrawn and has been replaced. The MPs are on recess, but they are expected to be recalled sometime in October. I suppose they were supposed to be back in October, but they'll be back in September, I understand. Now, let's listen to this clip, and we'll be back to that debate.
And then there were areas which electoral areas had been swapped. If you go to Asutifi South and North in the Brown region, all the electoral areas in the North were sent to the South and vice versa. If you go to Abuakwa North and South, the capital of Abuakwa South is Kibi, and that of the North is Kukurantumi. They were changed. We have a law, CI 46, which has 230 constituencies, which are perfect. Now we are going to revoke that law, create 275, which are based on a law which has so many flaws. So that if you don't take care in the end, you're not going to just affect the 45 new ones, but to affect every constituency in the country.
Sorry, you just heard Osei Kwame Prempeh. He's the chairman of Parliament Subsidiary Legislative Committee that worked on that particular CI, which was full of errors, but now corrected and placed back in the House. I'll start with you. Honorable Yunus Afuseni, the suggestion is that it appears that this is the creation, you are pushing the creation of the 45 constituencies only for political convenience. This is a way to reward constituencies that areas that you suspect will vote for you.
That is far from the truth. I mean, nobody has the ability of predetermining, beforehand, how the constituency will vote. I mean, to do that is even to subvert the supreme will of the people to elect leadership. I mean, we don't do that. We can't do that. You can't second guess a voter, can you? I mean, NPP did it in 2004. They didn't win all the seats, did they? I mean, so it's not there. It's just our quest to deepen democracy in this country, founded on law. What the Electoral Commission is doing is founded on law. What has come about, and I'm happy listening to the chairman of the subsidiary committee, subsidiary legislation committee of Parliament. He says that the CI that was introduced had flaws. Had flaws because some of the areas were swapped. I'm happy you are a lawyer. When an area is swapped, it becomes an error apparent on the face of the record. It's not a fundamental error. So when they went to the committee, and this problem, they should tell us. Indeed, it is the subsidiary legislation committee that created all these problems. When the LI 1983, the basis for the creation of the constituencies was laid before Parliament. They went as a committee to consider the LI. And they found what Honorable Prempe calls areas that have been swapped. So with the stroke of pen, they corrected those areas. They brought them back to where they properly belong. Because that was normal. I mean, it goes without saying, as the lawyers will say, that this is where it belongs, so it must belong there.
It sounds irregular.
Irregular. So they bring it back. And there was an exercise in their mandate as a committee by Parliament to look at allies. When they did that, what did they do? They failed to follow through to its logical conclusion. They failed to lay the ally 1983. So Honorable Prempe must tell the people of Ghana, all of us, why after having detected that some of the areas had been swapped, which was an error apparent on the face of the record, which errors they corrected in committee, but failed to lay the LI or advise the minister to withdraw what they felt was an error and lay the proper document.
I suppose that you are familiar with the Supreme Court ruling that suggests that you, Parliament, do not have the power to so correct any errors in an LI.
Yes, that's what I'm saying. So they didn't have the power. But they purported to exercise that power. And they not only purported to exercise, indeed they exercised that power. And that power resulted in an illegality. And someone took the illegality, the perceived illegality to court and got a stamp of approval from the Supreme Court. We said that Parliament, the legislative arm of government, has no power to correct LIs. They have power to withdraw the LI. So, when they corrected, the Electoral Commission proceeded to create constituencies based on the corrected version. The premise was wrong. You can't put something on nothing. When the Supreme Court said that the corrected LI 1983 did not exist, they had put something on nothing. And again, they say, well, why do you rush to create constituencies? I have a simple maxim in my language. It says when you hit your leg against a stone and fall, to determine the cause of your fall, you look at where you hit your leg, not where you have fallen. Now everybody's talking about indecent haste. I have said in Parliament that we ought to hold the committee accountable. Why did they mislead all of us into doing what they did? Why did they allow the Minister for Local Government and Rural Development to proceed on an ally that had no legal basis. So, yes, but why are we doing all these things? There are two ways of creating constituencies. One, the Electoral Commission suo motu, on the basis of the powers conferred on it by the Constitution, can create after a review of the number of constituencies in this country and the general population growth of this country.
There's a question that's also come up about that particular interpretation to Article 47, I think 5.
I've heard the people say that review...
The question of review, which we appear in this country to have only interpreted to mean addition. Do you think that that's a fair way to look at this particular provision of the Constitution?
I think that's a fair way. Mind you, when constituencies are created and there's representation, you create vested rights in people. You create them. And then you can only, and the Constitution in other provisions says that you cannot do activities or take actions which will adversely affect the vested rights of certain people.
So that we'll continue to create
constituencies until we cap
for
it.
as long as the earth exists.
Until there is a provision of the Constitution which says that we cap it here, and then we run with it. That's all.
Let me bring to your attention some interesting things that came up in the Constitution Review Commission. Some of the submissions that were made, those who made the submission noted that, and I'm referring to pages 500 to 502 of the Constitutional Review Commission's report. The people were concerned that certain governments create districts to reward sections of the population which vote for them, and in order to improve the fortunes of that an ethnic group that is seen to be sympathetic to the government or the party.
Well, they did the constitutional review and they have come up with this finding. But for me, as a student of democracy, creating districts, parceling out the country in manageable administrative sizes entrenches our democracy. You give a voice to the people. You deepen accountability when you partition areas of Ghana into manageable districts. Now, in doing so, you will send development. Because mind you, we have statutory funds for the development of the districts. So any district that you create is entitled to the benefit of that statutory fund. So you are spreading development equitably by creating districts. 2, the Constitution says a constituency cannot straddle across 2 districts. So in our quest to deepen democracy and accountability at the local governance level, we are mindful of the fact that a constituency doesn't straddle across 2 districts.
Whilst we are at the discussion, I would be grateful if you can refer me specifically to the reference you're making about the Constitution and its injunction that a constituency shall not straddle. Is it through?
Is it 2 regions or 2 districts?
2 districts.
Is
the
it in the
constituency
Constitution?
doesn't straddle across 2 districts. 1, because the constituency must be coterminous, but a district can have many constituencies. Because a district here is interpreted to include metropolitan and municipal areas.
Yeah, but I'm asking, in the Constitution, where is it stated specifically, categorically, that the constituency should not straddle between 2 districts? Is it not 2 regions, or is it rather 2 districts?
Districts.
I'm interested in the specific reference.
I
have the Constitution here.
When we go,
okay.
So you can move it on. So that
yes, I'll be doing
the Constitution
so.
and the local government. You have the Local Government Act?
The Local Government Act, I don't have it here. Okay, Nana, let me now come to you. We have heard the minority, come up with this posture that, we are in a hurry. We shouldn't be doing this at this point in time. But the question is being asked, why is it that this time you have problems with it, but in 2003, in 2007, the President Kufuor's government, undertook a similar exercise. We had the creation of the 60 new districts and upgrading of some to municipalities and metros. Why is it wrong at this point?
The problem at this point is time. The previous occasions which you indicated, I remember the 2004, the new constituencies came into force about 1 year before the general elections. About 1 year before the general election. The constituencies were created before February 2004. Compared to the situation that we have today, the new instrument has been laid. Parliament is on break. Parliament is supposed to come back from break on the 15th of October. Because the new instrument must lie in Parliament for 21 sitting days, the recall of Parliament, which is scheduled for 15th October, now has to be brought forward. Now, the Electoral Commission proposes to open the voters' register for the exhibition from the 3rd to the 10th of September next month. Members of Parliament must be in their constituencies for this exercise. So, presumably, the earliest time Parliament can be recalled ahead of the 15th October schedule, the earliest time would be after the 10th of September, because from the 3rd to the 10th, people must be in their constituencies to check their names and oversee the process. Now, assuming Parliament comes back on the 11th, that is immediately after the closing of the exhibition of the register, from the 11th, you must have 21 or thereabout sitting days for the instrument to mature, to become legal. There are 1 or 2 holidays, I think President Nkrumah's birthday, but that one comes to my mind. So you're looking at, for the 21 days to come to mature, you're looking at the 1st to the 2nd week of October for the instrument to have laid in Parliament for 21 sitting days, assuming we were even able to come back on the 11th of September after the the exhibition of the register. Now, when it becomes law in the 2nd week, between the 1st and the 2nd week of October, the Electoral Commission is opening the filing of candidates in the 2nd week of October, on the 15th, I think, if you look at their schedule, the 15th of October. The constituencies, the new constituencies become law in the 1st and 2nd week of October. Nominations must be filed to the Electoral Commission in the 2nd week of October. So what it's going to mean is that political parties must go through the processes prescribed by their constitutions of electing the machinery that would make possible candidates. They have just about 1 week to do that. 1 week. And even if you're able to select candidates and file by the 15th of October, those candidates have 1.5 months.
The NDC has already started that process.
Illegally.
Today, there are primaries going on in
on
Monday.
But we
there are
shouldn't,
primaries going on in
we shouldn't
Tamale.
credit an illegality. Like I said, the previous airline was rejected on the day it's supposed to become legal. This same airline may also be full of mistakes and may be rejected. So the tenancy of the airline begins when it's fulfilled the 21 days and it becomes law. People can be doing their backroom maneuvers and so on, but they are taking a risk. So when you look at the time constraints, in the light of the opening of the register, the printing of ballot papers and all of that, we still impose this on us. Time. It's become very difficult.
Will you
and
respond,
I've given you a very tight...
Will you respond then, to the recall? Will you respond to the recall to to come back to the House?
Oh, like I said,
and allow for the maturation?
The Speaker has the right to recall Parliament.
By the law, you're supposed to have 15% of the members of Parliament requesting the Speaker for a recall, and then the Speaker within 7 days, also within 7 days of the receipt of that request, summoning Parliament.
Yeah, I'm saying that there's no problem with the summon of Parliament. But I've said to you, I've given you the time constraints, that because the register will be opened between the 3rd and the 10th, it is going to be difficult to recall Parliament between the 3rd and the 10th of September. So the earliest time that will be reasonable to recall Parliament will be the 11th of September. And if you work it from the 11th for the instrument for Parliament to have 21 sitting days, you are going to go into the 1st and 2nd week of October. Now, when you go into the 1st and 2nd week of October, the Electoral Commission has fixed the 15th of October for the filing of nominations.
My suggestion to you is that if you think that the process is being hurried and ought not to be hurried in the way you presume it is, you perceive it is, then you have a part to play in the process. So are you going to decline, as it were?
No. We haven't come to that at all.
I'm
just telling you about the process going on normally. Normal recall of Parliament. If you recall it before the 10th, your members of Parliament will not be able to be in their constituencies for the opening of the register. So the earliest time you can recall reasonably is from the 11th of September. So assuming the Speaker recalls on the 11th, the 21 days will take us into the 1st and 2nd week of October. The Electoral Commission has fixed the 15th of October for the filing of nominations, because the Electoral Commission needs the filing to be completed in time, so they can print ballot papers and all of that for the whole country. So they fixed about the 15th of October. So what it means is that political parties, after the LI matures in the 1st and 2nd week, will have just about 1 week to go through their internal processes of selecting candidates. And even if they're able to do that, those candidates then have from the 15th of October to the end of November, 1.5 months to campaign. So we've put ourselves in a box. Now the difficulty here is, and I think that's what my friend Inusa was looking for, the Act 462, the Local Government Act, gives the government the leeway to create districts. But it also has a provision that districts should be coterminous, or districts should be, let me not use this kind of, districts should be the same. Districts should be the same as constituencies. That provision in the law, the local government law, passed in 1993 or so, or 1994, gives any government the chance to influence constituencies. So you carve districts as you like, and the electoral commissioner is obliged to transform those districts into constituencies. And the electoral commissioner is saying that because the districts have been created, if I don't make them into constituencies now, this year, next year you would have districts that don't form constituencies, and that would be in breach of the local government law.
Okay.
But then you also have this tight timing that the whole nation is being put into this box, as I've taken my time to outline to you. So
your position is that, as the minority has articulated, we should hold it and do it sometime later after the election? Because
the law that talks about the setting up of constituencies gives the electoral commissioner 1 year. So after the census. So when the census came in June, the electoral commissioner has up to June next year to set up the constituencies. So what it will mean is that but you see that the difficulty of the electoral commissioner too is that if you set them up in June next year or any time next year, you will not have elections into those constituencies until the general election in 2016. So we have a legal tightrope and a time tightrope that the nation is caught into. Because as it is, you have to bring parliament back after the 11th of October.
And when you do
September,
you have made that point.
You know, so it's a very, very tight box that the whole country has been put into.
You have made that point. I'll come to you shortly, Felix Kwachio Fosu. But I have on the phone lines the chairman of the Parliament Subsidiary Legislative Committee, Kwame Osei Prempeh. You heard him earlier, but now he's coming on to make what he says is a correction that ought to be made in respect of the submission that was made by the Honorable Inusa Fuseini. Honorable Kwame Osei Prempeh, good morning and thank you for joining us.
Good morning, sir.
Okay. Please proceed and let's know what your concern is.
Right, thank you very much. I'm surprised that my friend, Honorable Fuseini, is putting the blame on me for the chaos that has come about as a result of the passage of the LI 1983. At that time, it was a joint committee, and I believe that every member of the committee will bear me out that I made it forceful to the minister that, one, the Minister of Local Government has no power to bring an airline to create electoral areas. Per the Constitution, Article 45B, is the EC's duty to create electoral areas for the conduct of local and national elections. I made it. Secondly, after we have found that there were so many mistakes in the LI, we insisted that the LI should be withdrawn and a new one brought. But the NDC, which the majority, decided that they will pass it, just as they did with the District Assembly law. So that for anybody in the NDC to try to accuse me or the committee of having done a shoddy work, which has resulted in this confusion in which we find ourselves, is unfortunate. Like they are doing now, everybody knows that the CI has cannot pass. The CI has so many mistakes in it. And even this, when Dr. Farida was insisting that it should be withdrawn, the NDC majority, led by Majority Leader Honorable George Ho, were insisting that it should be allowed to pass. So, my brother, we have a legal problem now.
Do I hear you to say that the CI, even in its present state, cannot pass?
In its present state, it has major problems in it. It has a fundamental problem, and that fundamental problem is this. The electoral areas being used by the EC to create the constituencies is based on LI 1983. The LI 1983 was presented to Parliament by the Minister for Local Government. If you read the introduction, it says that the Minister of Local Government, acting on powers conferred on him by Section 334 of Act 462, brings this LI. If you read that section, it does not give the minister any power. So the minister did it ultra vires, and it has no, the LI did has no basis. So if the EC decides to use the electoral areas stated therein to create constituencies, the EC has a problem because it has no foundation. You cannot build something on nothing. So,
hello, Honorable. It appears that Honorable Osei Prempeh, we've lost him on the line there. But thank you for the correction that you sought to make. It's okay. I think we'll proceed from here. Now, Felix.
Yeah, thank you very much, Samson.
Before I start with you, I'd like to bring to your attention that the Constitution Review Commission, in its work, found that not only was the 2003 and 2007 processes, not only were they fraught with problems and perceived generally to have been done for political expediency, but the 2011 process also has problems with it. And it appears that it is also to serve, a political purpose.
Well, to the extent that the recommendations of the CLC have not been incorporated in any amendment that is to be made to the 1992.
This is a finding.
Yes, it's only a finding. But I'm saying that to the extent that it has not been adopted and incorporated into any amendment that is to be made to the 1992 Constitution, we cannot say much about it. When we get to the bridge, I'm sure we will cross it. But it is important to correct some distortions that have occurred in this whole discussion. It does appear that the lines of the debates are being blurred, and in the process, some distortions are being created. Now, first of all, government, i.e. the NDC government, has not created or sought to create constituencies. It is the Electoral Commission that is seeking, on the basis of powers that they've been given by the 1992 Constitution, to create constituencies. That is the fundamental issue that we must all get straight. So let nobody say that the NDC government is pushing for the creation of constituencies.
Isn't it not the mixed issue of the EC wanting to create constituencies and yet having its hands tied because the president did create districts?
Yeah, because the president also has powers, or government has powers to create districts. Government created a district. The Electoral Commission, on the basis of the districts that were created, said that they needed to act in a certain way in order that it does not appear that there is gerrymandering. That was a decision taken solely by the Electoral Commission, which is an independent body. And indeed, their independence is enshrined in the 1992 Constitution. So nobody can push them about, as it were. That must be gotten straight. Again, the issues must be delineated properly. There's a difference between the legality or otherwise of the constituencies that the Electoral Commission is seeking to create and the mistakes that were detected in the CI. They are two different things entirely. Listening to Nana Komia and other commentators, NPP commentators, I must say, it does appear that the goalpost is now shifting from, oh, the EC doesn't have the constitutional mandate to create districts, to we have limited time. Now, if the Electoral Commission has the power to do what they are doing, why should time constraints prevent them from doing so, given that they themselves are confident that they'll be able to do this in a manner that would enable them carry it through into the 2012 general elections? Who are we to dictate for the Electoral Commission how they should go about their duties? And you must always bear in mind that they are an independent body. If they feel confident that they can do this, I think that we should allow them to do their job. First, when the Electoral Commission broached the subject of creating new districts, we immediately were confronted by claims by MPP and other commentators that Article 47(3) requires them to create constituencies whose boundaries as far as possible reflect the population quota. The impression was created that that is the only provision that must be met. However, if you go to Article 47(4) of the Constitution, it makes clear that other considerations, such as means of communication, in other words, how MPs are able to interface with their constituents, geographical area and all that, must be taken into account. Because if you have a sparsely populated yet large area, those constituents in those places need to be able to interface with their member of parliament so that he can best represent them. So if the Electoral Commission deems it necessary to carve out areas out of these unwieldy constituencies, I think that it is proper to the extent that it is consistent with the law. And I believe that from where I'm sitting, I'm not a lawyer, but reading the Constitution, I want to believe that the Constitution is hard that lay persons also can read it. Certainly. My reading shows that the Electoral Commission is seized with the power to do what they are doing. The argument of timing, again, for me, is inadmissible. To the extent that the NPP itself has made certain demands of the Electoral Commission. When arguments of time and even resource constraints were raised, they still pushed through. When they brought the subject of verification, they were insisting that there should be verification. Some of us felt that, first of all, it was even unnecessary, given that verification is inbuilt in the system. Again, we may have a difficulty with raising the resources for it. The NPP insisted that we must find the resources to do verification. So time constraints, resource constraints have never hindered the NPP from making certain demands or recommendations to the process that the Electoral Commission has to oversee. Therefore, I do not see why they can use similar arguments to defeat something that is legitimately being done by a constitutionally mandated body. So I think that argument must rest. Now, coming to the CI, why does Parliament have to go through, or why do these laws have to be put before Parliament? Because the framers of the Constitution envisage that somebody has to exercise oversight responsibility over some of these agencies. So Parliament is allowed to conduct scrutiny on some of these things. Therefore, the Subsidiary Legislative Committee was simply doing its job when it detected problems with the CI. So that should not raise any controversy. All that needs to be done is that the CI needs to be taken back and corrected and relayed.
Which has been done.
It has been done. So why this controversy? Why are people creating a precedent?
He's raising a fundamental issue also, that the CI ought to be laid by the EC and not the local government minister.
Which CI? That two CI. But this CI was laid by the Electoral Commission. The one governing the creation of constituencies, was it not? Was it not laid by the Electoral Commission?
Listening to Osei Mensah Bonsu, and you...
No, I thought that it was the one covering the LI. So they are two different. Yeah, so those are different.
Which creates a district.
So those are different issues altogether. The CI was laid by the appropriate body, which is the Electoral Commission. The mistakes that were detected were not fundamental. They do not ultimately alter the validity of that document. Clearly, these are typographical errors. There are instances where, for instance, Okaiko is out. electoral areas and polling stations that should be in Okankwe that have been put under Okankwe North, and vice versa. Clearly, there is a typographical error that can be corrected. By can be corrected. It was going to type Okankwe North.
But Felix, the question that is being asked, the question that is being asked is that why do we seem to be behaving as though without the new constituencies we can't have an election?
No, but nobody has behaved that way. The Electoral Commission, which is the body mandated to create constituencies, says that they are going to create 45 new constituencies and that they are able to do it in a timely manner so as to make it possible for them to have elections in those places. In 2012, who are we? Persons who are not mandated by law to question them. All we can do is to raise issues and concerns. But beyond that, we cannot tie their hands and insist that they must do things our way. That's the point that I'm making.
Do you remember that the NDC in opposition in 2003 was against the creation of the new districts and constituencies?
Well, I'm not aware of any official opposition or official opposition against what the Electoral Commission was doing. In any event, the Electoral Commission went ahead and did. The NDC participated in the election that were conducted in this district. And like Honorable Newsfile rightly said, I think the NPP won 18 out of those constituencies. We won 12. So who is to say that any particular constituency will vote in any particular way? For which reason, if you say that the Electoral Commission should be supported to do their work, then you are obstructing just what I believe has happened really is that from day one, the NPP has been opposed to this thing. We saw how various commentators of the NPP opposed it. They publicly criticized it. And we've seen how people have gone to court. And I have strong suspicion that the NPP was behind some of those cases. Fortunately, most of them have been thrown out and have no effect on this particular process. But I think that the controversy is unnecessary. The fact that mistakes have been detected does not mean that what has to be done constitutionally must not be done.
Abdul Malik, let's hear you.
Look, the point Alhaji Fuseni made, which my brother Komia appears to agree with. I've searched through the Constitution. I can't find it.
No, it's not in the Constitution. It's in the local government.
It is also not there. I'm looking at it here.
Can you read Article 47 and combine Article 47, 3 and 4, and particularly give true meaning to administrative areas? You see, it's administrative and traditional areas. All traditional areas.
You are interpreting it for us.
Administrative or traditional area.
No, let's understand.
What is it?
You read it and you say
districts vis-a-vis constituencies.
He said
I think what Kwekwe is talking about is that
no constituency should straddle or traverse.
There's been a consistent reference to the Constitution or some law, which we have not been told which law it is. That insists that you ought not to have a district.
A constituency traversing two districts.
But I'm saying I can't find it.
Exactly.
I say read 3 and 4.
Either
local government.
3 and 4. See what it says. 2. Let's see.
No
constituency shall fall within more than one region.
More than one region.
Then the boundaries of each constituency shall be such that the number of inhabitants in the constituency is as nearly possible equal to the population quota. 4. For the purposes of clause 3 of this article, the number of inhabitants of a constituency may be greater or less than the population quota in order to take account of means of communication, geographical features, density of population, and area and boundaries of the regions and other administrative or traditional areas.
Administrative or traditional areas.
No, this is your interpretation. No, so this is an interpretation that you are making. It's not explicitly stated here in the Constitution. The framers didn't tell us that what you are saying is so. So if anything, we should go to the courts and determine the outcome.
I also wanted a direct reference. I couldn't get, but reading the Constitution carefully.
No,
it's still that is why you can have NAPDAM, have 13,000.
My brother.
Because
it is still an interpretation by Alhaji Fuseni.
Because I understand that
who is not a Supreme Court judge.
The best practice,
the
best practice I pray for is the 3 key points of geography, economic viability, and synchrony with traditional areas.
Traditional or administrative. Is that in the Constitution?
Yes, but I'm saying that what you said is not what the Constitution is saying. Yours is an interpretation.
Okay.
And even in the Local Government Act, which I'm looking at, I've searched and I can't find it.
All right.
Okay, and I have a problem. I think that at the end of the day, we need to ask questions, because if you read the Constitution, for me, I think the principal element is the population quota and the fact that make sure the two things don't cross against across two regions. They are principal. Yeah, there's the exception thing regime where the EC can do those things, communication, population density, and all the rest. But those are not the principal ones. So you cannot proceed in creating new districts, constituencies, or increasing constituencies by making those subsidiary elements, the exceptions one, become overriding. We can't continue doing that.
Let me tell you why we should be mindful. Just a discussion.
Sure. No problems.
You know, when you are interpreting all these things, you must interpret it in the context of jurisdictional issues. Assemblies have the power to make bylaws. You have a constituency straddling across two districts. At what point does one district bylaw affect the constituency?
There'll be a problem.
See, it may sound technically and administratively or organizationally sensible to ensure that that doesn't happen. But I'm saying that's not what the law has stated.
Okay.
And the fundamental law is this one. So if there's any attempt to create a new law or to interpret a certain provision of a law to that effect, it ought to be challenged and properly dealt with at the appropriate forum, which is the Supreme Court. Because if you go, I've tried. Yesterday I tried some, asking few questions. And the support, the UC appears to use the Section 5 of at 462, Composition of District Assemblies, the 5.1c, which says the district assembly shall consist of the following members. And the appropriate relevant one is the 1C, the member or members of parliament from the constituencies that fall within the area of the authority of the district assembly, except that such member or members shall have no voting rights. Okay, this appears to be what is hinged on. This provision is also in the Constitution. If you go into the decentralization place,
that you cannot have a district that has no member of parliament.
That is the interpretation they are giving to it. I'm saying that it's suspect. The interpretation is suspect, or it might not be sustainable. The best forum is at the court to challenge this thing. But having done that, let me be honest with you. I recall this matter came up on this table one time, and I expressed my frustrations. Indeed, my brother thought I was expressing pessimism, about the processes. It's so untidy. And I'm with Akomia on those aspects of the matter. Look at the election cycle. Look at where we are. I'm so, that maybe the two major parties do not really bother because they think they have their structures on the ground and may be able to move into motion relative to the exercise. But otherwise, it really doesn't make sense to me that we have about 3-4 months to an election. We are now creating new constituencies. The parties are going to have to go to primaries, select candidates who will be marketed. Okay? I'm beginning to think that those two major parties, particularly the ruling one, is comfortable with the time frame and all the constraints involved because perhaps they have the logistics and the infrastructure already on the ground. Otherwise, to be honest, it doesn't make sense. It doesn't speak well of us. And it's all coming with all sorts of mistakes, errors, which Parliament then has to get the EC to come back and withdraw. Supreme Court has passed some rulings that already affect fundamentally, and that's what the Seprempe was telling us. Some of the issues. Why are we doing this to ourselves? And strictly speaking, are we going to continue? And my brother Fuseni was okay with it. Continue increasing parliamentary constituencies to God knows when? Is that what we're going to continue doing? The Independence Constitution had a ceiling.
Yeah. But this one has no
Article 22. The 1979 Constitution had a ceiling. We better start thinking along those lines because we cannot. Countries that have bigger populations, bigger landscape, have smaller
But you see,
parliaments than what we have.
Kukubaku.
I think we should be expanding the decentralization process. Look, if we want representation, if we are talking of representation and the development that it brings, then let's look at our decentralization system and expand it and deepen it and bring it to the people, rather than looking at only the legislature. Representation through the legislature must have a certain limit.
How about also the question of abuse by regimes, by governments, because of the president's power to delineate districts? We are told that by the Constitutional Review Commission that such power should be given to both the president and the EC, subject to the approval of Parliament. In Namibia, they give us the example of an independent commission that does so. Elsewhere, we are told of independent commissions that do such delineations. Shouldn't we be going this way, even though government has rejected that proposal?
Human nature being what it is, I will proceed along that line. I will go with that cure for this mischief. Okay, some groups have been consistent. I mean, the CDD and some civil society advocates like Professor Asari and Prempe and the rest. From 2003, when the NPP decided to create, the NPP thing, it was the other way around, but there was still a contest over it. There was still a contest. The NDC and others protested. Indeed, somebody went to court, but the court ruled in favor of the plaintiff. The plaintiff who went to court was supporting the EC. I think that's what happened, and the court ruled in favor. Yes, human nature being what it is, I believe we should find a way of curtailing the executive's, test for increasing, building, creating more districts. If that is how the EC will be compelled to come in, because the EC appears to have adopted that philosophy that once districts are created, then it is compelled to create more constituencies. They've come up with that theory, which is not constitutionally founded. And as I said yesterday, a EC spokesperson referred me to Section 5(1)(c) as their legal basis. It wasn't convincing.
Yes.
But that's their basis. The truth is that this matter ought to be litigated in the courts. As we speak here, there are legal challenges.
Yes, we understand about 4 of them.
Some of which have been thrown out.
Well, not the principal ones.
Yes,
not the principal ones.
Interlocutory.
Yes, not the principal ones. Yeah. And we are ignoring all that. The potential.
There's no injunction at the moment.
No, I'm saying that could happen. It could happen.
I think you truncated my...
merely taking the matter to court cannot stop everybody that is mandated to do something from doing it.
I know
Unless
that.
there's a specific injunction that says
the recent
by-elections.
By-election. The EC was sure. It was based on law. And there was a part of the law that backed it. And others thought that, look, it really wouldn't help matters. Yeah. In spite of what the law says you should do.
And the court agreed.
And what did the court say?
Yeah, but so we should court says otherwise, the EC can go ahead.
I'm with you, but I'm saying we should anticipate. Right. When you are doing these things, you must do it with some anticipatory thing too. Okay? That it could happen. Especially when there are live cases in court. But the whole thing is messy and untidy. And I'm not blaming the EC as such. I think as a nation, we could do better.
All right. We now go to the next issue that I introduced to you earlier. And the NPP have been making some suggestions that President John Mahama has been telling the nation that he is, a nice guy. And so ought to be giving the mandate to continue with being the president of the country. They have labeled him as having been corrupt and incompetent, and he and his vice, they say, offer nothing new. Is the NPP in a hurry to label the vice president in a negative manner just for the politics of it, or what they are doing is with sincere hearts? Nana Akomia is communications director of the NPP. You held your press conference. You had a gamut of issues to level against the president. You said he's incompetent. You made charges of corruption and a whole lot against him. Where are they coming from?
Well, thank you, my brother. Just half a minute to The business about the Electoral Commission has the constitutional mandate and the legal basis.
And now you're taking us back.
Oh, just half a
No, you're
minute.
taking us back. If you did so, some other members of the panel would also demand an opportunity to speak to it, and we can continue.
When the constituencies have been created, political parties have to operate. So it's not like it's just due to the Electoral Commission to do what it wants. It doesn't operate in a vacuum. The decisions it takes have to be responded to by the political parties. So the issues that we have raised are very important. Now, John Mahama and the new team, the party at the press conference, essentially to thank Ghanaians for the show of solidarity in the difficult period when the president died suddenly, and all of us needed to pull together to make sure the transition came on as scheduled, and also the funeral arrangements had a national character. And so we had it to thank Ghanaians. The NPP itself suspended all its political activities. The flag bearer or the presidential candidate suspended his campaign tour, came back to Accra immediately. He heard the news of the demise of the president. The very next day, the party hierarchy went to the castle to offer condolences and support to the new president, who had been sworn in just the day before. The presidential candidate also rearranged his calendar. Apart from cancelling the campaign tour, they had an IEA platform for him to use. He asked that it be rescheduled. The constituencies were asked to suspend their political activities, fundraising activities, campaign launches.
And if you don't mind, let's fast forward to the charges of incompetence, lies, broken promises, economic mismanagement, and what you said is unprecedented corruption under the watch of John Mahama.
I'll do that in a second. So we had pulled together, and the chairman of the party sought to acknowledge and thank the party supporters for obeying what the party had said. And then we also welcomed the new ticket of John Mahama and Amy Saata. And then we sought to tell Ghanaians that as far as we are concerned, it is still the same. Our message will be the same. It is still the failures of the NDC government. The John Mahama, as vice president, was central in the NDC government. He's chairman of the Armed Forces Council, chairman of the Police Council, chairman of the Economic Management Team, and he himself had said that the President Mills gave him every responsibility. So the failures of the NDC government, which we believe would influence the vote in December, John Mahama cannot escape those failures. And we outlined some of them. We talked about his stewardship as the chairman of the Economic Management Team, and Amy Saata's stewardship as the governor of the Bank of Ghana. We said that look at the economy as we speak today. Even though we have the blessings of oil revenues, and even though we have taken the biggest loans in our history, you still have a situation where interest rates are almost 30% as we speak, when they were 26, 27% 4 years ago. You still have the cedi losing 80% of its value in 3.5 years, even with the blessings of oil and with the huge inflows of foreign exchange in terms of loans that we have acquired. You still have this macro situation. We're told that inflation is single digits, and yet the cost of living, the price of any item that you can think about that you go to buy, whether it's bread, whether it's sugar, or whether it's whatever, the price have gone up by triple digits. So the cost of living in the last 3.5 years, especially in the period after January this year, is just terrible. And I'm amazed when government officials don't even seem to realize it, and they keep telling Ghanaians that they've never had it so good. The fundamentals of the economy, where we are raw material producing, raw material exporting economy, since Gogisbeck's time, where it hasn't been changed. Nothing has been done to touch those fundamentals, to transform the economy. Even when we got crude oil, we are still digging the crude oil in the raw form and exporting it raw. We have made no effort to put our refinery in order so we can process our own crude oil, turn it into petrol, which will sell at least twice the price of crude oil. So the fundamentals of the economy remain the same.
So you say they have not changed since Gogisbeck, and that is you're admitting that in the 8 years of the NPP, they have been the same anyway.
Well, we are offering a new leadership in the person of Nana Addo Dankwa Akufo-Addo. We're saying that this team has been in the saddle for nearly 4 years. In those 4 years, they've had every opportunity to show Ghanaians what they can do. Now, if they haven't done it, or they haven't showed what all they've shown to Ghanaians, in the 3 months that are left, we don't see what new thing would be brought on board to improve the welfare of Ghanaians. We also talked about some of the...
What specifically has been your expectation that have not been met?
I've told you. Look at the city. The city, the lifeblood of the economy. That really is a thermometer which shows how well the economy is doing. Look at the city. It's lost. If you had 1 cedi in 2009, today that 1 cedi is worth 20 pesos. You know, and you look at the cost of living. Every item has gone up, in some cases, 400%. Whether it's bread, whether it's sugar. As a radio station, I invite you to do a weekly update of prices just to sensitize the government itself as to what is happening in the real marketplace. We also talked about some of the specific projects that John Mahama championed. STS, for example. And we are of the belief that the whole STS deal is tainted with unanswered questions. Apart from the fact that it failed woefully, despite all the advice and the noise that was made, it failed flat on its face. But you even look at the specifics of the deal. Indeed, when President Mills announced this deal in Parliament, he said that he was the Vice President, then Vice President John Mahama, was going to Korea to put the final nail in the coffin. And that has proven to be very prophetic. The STS deal is still born. But you look at the pricing, you can't explain it. That 1.5 billion loan to construct 30,000 flats works out to about $50,000 per flat. This is beside the point that land was free, and really land is probably the most important part of the cost. The difference between a house and in Kokomimle and a house at Dowenya is where the land value. As for the bricks and the mortar, it's just the same.
And this is the basis of your corruption claim against him?
Yes, and you saw 50,000 houses, 50,000 per flat. When you had Ghanaian contractors constructing 2-bedroom houses, not flats, semi-detached and detached, going for 30,000, 40,000, 50,000. And yet we agreed to a pricing structure that was costing a flat at $50,000. So I had a problem. And you had a situation where the grader, which is the local building industry, had said that given the same support of land and electricity and roads and water and tax exemptions that have been given to the Koreans, they would price the 30,000 houses at less than half the cost. But we still went ahead. The Koreans, after the whole deal fell flat, are demanding $17 million. They said that if they didn't get that amount of money, they were going to spill the beans. What beans were they going to spill?
What's the corruption in this?
The pricing. After the questions about the pricing have not been explained. So we suspect that there is corruption. Otherwise, why would you agree to a costing that is totally unreasonable? Why would anybody do that? Then John Mahama was also in charge of the acquisition of the Embraer aircraft. And the nation was told that decisions have been made to put in an entertainment system that was costing $1 million, and that decisions had been made to construct a parking hangar for the aircraft that was going to cost $17 million. we think that those decisions were not wise. That in the light of the difficulties that we have as a nation, more prudence could have been exercised. And that those projects were directly under the purview of John Mahama. So we're saying that the two of them, the ticket, the John Mahama, Amy Sata ticket, have been at the center of economic policy, social policy, whatever, in this country in the last 3.5 years. So it is not a new ticket.
Do you find that you are preaching the politics that the president in his broadcast discouraged?
What? Discourage what?
The politics that brings disunity.
What politics that bring disunity?
I'm asking,
criticizing the government
from all the issues that you raise and label him, put on him.
But these are objective issues. Wasn't he the chairman of the economic management team? He was. Wasn't Misata the governor of the Bank of Ghana? He was. Don't they have responsibility for monetary policy, including interest rate, including the value of the cedi? Didn't John Mahama go to seal this STS deal? So these are issues. We are criticizing the record over the last 3.5 years.
So hold on at that point for me.
Okay.
Now, Felix, how do you respond to these allegations? And they sought to list them. Questions of incompetence, corruption, and a number of them.
Well, I had the opportunity to respond almost immediately after that press conference. And I said that, well, no sooner had we laid our departed President Mills to rest than the NPP returned to their bland, old-fashioned politics of peddling falsehood, unsubstantiated allegations, personality attacks, and very, very, if you like, mediocre analysis of national issues. And look at the allegations that they've tabled.
If you can speak up a bit.
Look at the allegations that the NPP has tabled. And Nana Komia struggled to point to you where the corruption was in the SDSD, for instance. I don't think Nana Komia is suggesting that merely because a loan deal falls through, the government is corrupt. Otherwise, the NPP had 2 loan deals that fell through. They would be the most corrupt government in the history of Ghana. Because the CNTCI loan, which was sourced from a hairdressing salon,
it fell
it was.
I did not
interrupt you. I did not interrupt you.
Okay.
You got the pricing even wrong.
Oh, really?
Okay.
The NPP,
please make note of the things that you.
I mean, it was Matoda Santi who reported from London that the address that they gave for the CNTCI was a hairdressing salon. The IFC loan, they made a lot of noise about it, that $1 billion was coming. It never materialized. Nobody called them corrupt because of those transactions. Again, it is not true that a flat would cost $50,000. If you divide $1.5 billion by 30,000 housing units, that is 50,000 per housing unit. That is even if you are doing an average price. But the flats were all not going to be the same. There were different categories of flats which would cost differently. It is an aggregation that gave you $1.5 billion. You see, when a political party wants to do analysis, they must be more in-depth than that. Don't do blanket generalizations and sweeping statements when you have absolutely no basis to back it. How do you simply say that because a housing unit is going to cost a certain amount and Grader is saying that they can provide it for another amount, that mere fact constitutes corruption? This is a party that is desperate to look for mud to stick at the president. Again, it is even more ridiculous when you go to the SADA allegation that they make. They cite SADA as an example of corruption on the part of His Excellency John Mahama. Now, government promised to set up SADA.
Cited?
Yeah, under corruption. Yeah.
It was cited under...
No, it is here. It is here. Corruption. Read your own statement. Corruption. Okay. They cite President John Mahama was the same man who, against all competent advice, engaged in the STS deal. Similarly, John Mahama is the face of the NDC. He championed the SADA project, and you put it under corruption. Yeah, your own caption. After corruption, you spoke about judgment debts.
So SADA, they were referring to the promise that has not been kept.
They put, again,
that's a fact, isn't it?
There are 2 issues. It is not true that the promise has not been kept. That's the first point. Again, they put it under corruption. Corruption, that's the heading of that whole. So they cited STS, the Embraer Jet, and SADA. All 3 allegations, I'm telling you, are baseless. They are false, and I'll prove it to you immediately. To date, SADA has been given 260 million Ghana cedis. They received 30. That's not what you promised. Please. That's not what you promised.
No, hold on.
They were given 30 million Ghana cedis in 2011. 30 million Ghana cedis in the 2012 budget. This year, they've received 2 tranches of 100 million Ghana cedis each. 260 million Ghana cedis. That roughly, at the time that they were getting that money, roughly it was about $120 million. between a situation where the NPP did not give the people of the northern Ghana in any development fund a penny, and a situation where now SADA exists and has $120 million to deal with, which party is more responsible towards the people of the northern Savannah ecological zone? Again, because of this.
No, but Felix, SADA has been how many years?
Oh, but no, listen.
No.
If you check the NDC manifesto,
if you could oblige me this.
Yes.
SADA is how many years?
SADA was set up in 2010. That's the time that they were set up.
Okay.
Again, between 2010 and now, you have to. You see, we are building.
The promise was 200 million Ghana cedis for a start, and then 100 million each year.
Allow me to explain. Hello. Allow me to explain. I'm saying that between a situation where the NPP provided zilch for any development fund for the north, and a situation where the NDC government has given $120 million to SADA to execute its project. SADA has partnered the produce buying company to set up a share nut processing factory that produces 40,000 metric tons of share nut annually. Between that situation and what existed under the NPP, which one is more credible? Again, how does the mere fact that we've given $120 million out of $200 million connote corruption? Is that the sort of analysis that should be done by a serious political party that wants to win political power? Let me come to the embryo matter. You see, again, I recall when the embryo matter came up, how the NPP rushed to make baseless claims that were not supported by the facts. A serious political party wants to discredit a deal that the government is engaging. They want to give evidence of corruption. You know what they did? They went to a blog operated by somebody who calls himself an aircraft enthusiast, www.aircraftcompare.com. And they went to check prices put up there by the blogger. Indeed, on that same website, the blogger issues a disclaimer that the prices that he is quoted there do not reflect the actual prices. He indeed invites visitors to the blog to provide him information as to the actual prices of the aircraft. I would have imagined that the NPP will go to the website of the manufacturer of the aircraft, because to allege corruption, what the NPP is saying is that the Ghana Armed Forces, the Ghana Air Force, led by Air Vice Marshal Samson Oje, who has rendered 4 decades of dedicated service to this country. The president of Ghana at the time, President Mills, Vice President Mahama, who spearheaded the deal at some point. The Brazilian government, that is facilitating the loan that we are getting from the Brazilian financial institution. The Brazilian military, who would vet this aircraft because it is a military aircraft, and all the other Brazilian officials are corrupt in order for this deal to be corrupt. That is the argument that the NPP is making. And I'm saying that, you see, this sort of vacuous, vacant analysis must give way to proper, nuanced, well-researched analysis that will enrich the discourse. And that is why I said that the politics that the NPP displayed was old-fashioned. Again, they speak about economic mismanagement. Something, if you want to assess the health of an economy, there are specific indices, they are objective, they are universal, they are global. That is what is done everywhere.
They've told you about the CD.
That the CD is not the only measure of economic success.
It's an important indicator.
It is an important indicator nonetheless. In any event, let me put it on record that the CD has lost 58% of its value since 2009. It is false that the CD has lost 81%. Within 18 months, between 1st July 2007 and December 2008, the CD had lost close to 40% of its value, with Dr. Baumia in charge of the economy, as the NPP would have us believe. Within 18 months, almost 40% of its value was eroded. In 3 years, it's been 58%. In any event, who says that it is the first time in our history that we've had this difficulty? Any objective observer of our economic history will tell you that in election year, save 2004, and indeed, when you are doing analysis, you don't pick the exception, you don't pick the outlier, you use the norm. That has been the trend. But even then, government has put in policies that has helped stabilize the city. Beyond the city,
is it stable?
Oh, it is more stable than it was 3 months ago. You understand the point I'm making? After government floated bonds in order to mop up the excess liquidity, that was putting further pressure on the city. Beyond the city argument is a larger issue of economic management. Let me put it on record here that between 2009 to date, this country has had the most stable macroeconomic environment ever. Inflation, NPP, at the beginning of January 2008, under the NPP, inflation was 12%. By December, it had skyrocketed to 18.1%. Today, we've brought it down to single digit. For 25 consecutive months, it has been a single digit. Our growth rates, they speak about oil. Oil contributes 1.6% of our GDP, a mere $400 million. If you juxtapose that against almost $50 billion in terms of our GDP, that is a drop in the ocean. So it is not oil that has made our economy improve. But we've recorded 14.4%. NPP left us with 8%. They left us with unprecedented budget deficits of 14%. A situation that has collapsed otherwise strong economies like the PIGS nation, Portugal, Ireland, Italy, Spain, and Portugal, and Greece, I beg your pardon. Those nations are collapsing because of astronomical budget deficit. That is the sort of budget deficit that the NPP left us. Today, our foreign reserves, we have almost 3 months import cover because we have over $4 billion sitting in our external reserves. The NPP left us a paltry $1.8 billion, which represents 1.8 months of import cover. This situation, as the NPP left it, cannot compare to what we have. Now, beyond the stabilization in the macroeconomy lies the impact that government's policy has had on the citizenry. Those hundreds of thousands of public service workers, public sector workers, who upon the implementation of the single span salary structure, because government has raised $6 billion, billion Ghana cedis, the budget for payment of public sector workers annually has risen from 2.5 billion to 6 billion. The NDC government is raising lack of money. And because of that, public sector workers enjoy more pay today than they ever did under the NPP. Again, those young men and women who were unemployed under the those young men and women who were unemployed under the NPP, who today are employed in the Youth in Agric project, the Eco Brigade, the LESDEP, the YesDEC, those artisans who were given employment because of projects like Schools Under Trees, where almost 2,000 schools were constructed, roads have been constructed, hospitals, and what have you. Those people will disagree with the NPP when they tell them that their lives have not improved, because it is better to have employment under this NDC than the situation where they were unemployed and were sitting at home and doing nothing under the NPP. So when you put all the, and the final point, I beg you, they speak about politics of insults and say that because President Mahama described the debates that characterized the choice of venue for the burial of President Mills, he described it as useless. He has used words that are unacceptable and that he is insulted. Meanwhile, in that same press conference, in that same sentence, the NPP describes the debate as unnecessary. If something is unnecessary, can it be useful? And if something is not useful, is it not useless? In any event, who says that the NPP can go scot-free when it comes to politics of insults?
They have also suggested that if he's preaching against the politics of insult or intemperate language, he should be seen to crack the whip.
So does the NPP believe in cracking the whip?
NDC
no, but does the NPP believe in cracking the whip?
Very unprintable language.
At least President Mahama has made a public statement indicating that he would rather we have decent discourse. Nanado had opportunity to sanction his members who used indecent language. I mean, and I regret very much to cite Nana Akumi as an example. He used words here that I cannot repeat.
No, but he's the president.
Listen.
He's the president,
no.
so if he's making the call...
As far as I'm concerned, the standard for a president is the same as somebody who wants to become president.
All right,
you should be able to act like a president if you want to become president. Nanado, this is the final point. Nanado failed to sanction Nana Akumi. He failed to sanction Gabi. He failed to sanction Kennedy Japan. He could not even publicly criticize Kennedy Japan for calling for people of a certain ethnic extraction to be murdered. So the NPP has absolutely no moral right to speak about the policies of insults.
Mr. Kwekubako, there's a suggestion that this press conference by the NPP and the issues that they raised, the charges that they leveled against President Mahama and his vice, is sort of a preemptive strike to seek to smear him so that they would be able to refocus their campaign, you know, following the demise of the president.
Well, the politics has begun. It's in full swing. I think yesterday I heard the president on a thank you tour, which was virtually a campaign, as far as I'm concerned. No, it was campaign. Absolutely, the president is campaigning. No doubt about that. I thought the thank you or the expression of gratitude on the national, the broadcast was
done with the broadcast.
That's fair. That was okay. If anything, is the family in the central region would come and also thank the president. I don't see why the president should be touring the nation. I'm told he will be in the western region to do thank you, and in the process promising how to rehabilitate or build a market and a stadium. Come on, it's in the campaign mood. Let's strip that out and look at the issues as they are. You know, and the NPP is politics. They've launched the campaign. We can interrogate the specifics and where we think is just laced with propaganda. Let's point it out, okay? But across the divide, they are all going to do things like this, okay? It didn't start today. The NDC in opposition marshaled a lot of things. Vodafone, they said, was corruption, synonymous with corruption. They gave us no evidence.
This appeal for you.
Oh, he did not.
He says he did
He did not. He made an allegation. And when this government came into office and set up the review committee, he appeared before the committee. Have you read the committee's report? That he was unable to substantiate the allegation. So that's where it stands.
But that's the difficulty with corruption.
Yeah, so why do you make the allegation? I'm not looking at it in terms of which party. I'm saying that he made an allegation. Let's be honest, the NDC out there challenged the divestiture on so many levels.
Not just
corruption was one. That Ghanaians were capable of managing their own companies was one.
Point,
But you divested some companies since you came into office to foreign interest. I mean, we do these things to ourselves. We've been doing. I don't really mind.
Sorry.
You know, we've been doing these things to ourselves. So let's be honest. There are certain aspects. Of course, to be honest with you, when I read the NPP statement, my brother says it came under SADA, came under corruption. In terms of the title, but if you read it carefully, you realize that they were not looking at SADA within the context of corruption, even though the title gives that impression.
So
it's up to them how they drafted
that's their
it.
mistake.
It's their mistake. It's how they crafted their statement.
So
because if you read it carefully,
it's all right. Move
it comes
on.
to similarly, John Mahama is the face of NDC broken promises. He championed the SADA project, a concept stolen from the MPPs, not in. So I can see that in terms of the drift, they were looking at SADA as a classic example of broken promises. Okay, I don't have the same position relative to STS and SADA. I am not able now to see evidence of corruption relative to STS. I can't see it. You can say it was a bad deal, poorly handled,
And I
poorly
spoke about suspicion.
yeah, but suspicion is not evidence. Okay, so it is a case that the NDC will have to pay a price for. Don't forget the late president cut a sword and promised a time frame. And there were people who went on air and said, look here, we are delivering. It's a promise they made publicly. There were a lot of problems in Parliament over that particular project. Nobody listened to the minority and other civil society groups. At the end of the day, I think we are all clear in our minds that the STS project has collapsed. It's a minus for government. I don't see it as corruption matter at this stage. If future evidence brings corruption issues, I think we can tackle it. But it's a case that is still very negative. And I'm not sure. I hear government spokespersons seeking refuge in the so-called boardroom wrangling as an excuse for the failure or the fiasco. There was boardroom wrangling, but I'm not too sure you can reduce the fact that this thing collapsed to just that. I'm not too sure about that. We may raise issues of even then due diligence in terms of the characters that had come on board. In any case, did government not have an interest?
Yeah, we did.
We did. Yes, how did we police or protect our interest? As far as I'm concerned, it's a bad deal. I was a supporter of it.
Who is it being demanded from?
No, but has 70 million been paid? The mere fact that somebody makes a demand, that's
those
not why
are-
that demand.
Oh, but it's an invalid demand. That
On government. Why are
Sorry,
they making that
sorry,
demand on
but-
government?
Yes.
That's not-
Sorry,
You
let's
see,
allow
so those
Kuku.
questions must be raised, and answers
I need some
must be provided to those questions. But I don't think we should jump the gun and conclude that it's evidence of corruption at this stage. You don't do justice to the issue if you jump the gun and say it's evidence of corruption. But indeed, why do you want to shout corruption when the thing is even so bad that the government must be embarrassed? I am embarrassed because I was a strong advocate of that project consistently. And so there's some embarrassment. I mean, let's be honest. So there's how we craft this statement and how we go about our campaign. And so for me, what we should be doing is to look at the issues they've raised. You know, economy. I totally agree that the value of the cedi, or if you like, the rate of depreciation, the way it's gone, he says it's been arrested in a way. I don't see much of it. It's so minimal, so marginal.
The city loses some value, but it is about the rates of depreciation.
We were
that is
promised
worrying.
that June, we were given a deadline of June. If you recall, the finance minister said they had put in place some measures, and by June, it went worse.
No, it's halted. For the
June?
last 3 months, it's
It
not
did?
been as
Just want
bad.
to, you are going to do propaganda.
No, not propaganda. You are saying things that you've not found.
just hold it, just
I'm
hold it.
correcting it that I say propaganda.
Kuku,
The city still do propaganda.
Kuku,
so how
The
the-
city
kindly wrap up in 2 minutes for me.
The point I'm making is that the economy the opposition parties have every right to point to difficulties and challenges confronting the economy and to use that as a basis to mobilize public opinion and support in their favor. That's what the NDC did. The Kufuor administration had done a lot also on the economic front, but there were challenges. The NDC capitalized on those challenges. And at the end of the day, appear to have convinced majority of the electorate to vote for them. I see nothing wrong with that. But we should also be honest and critically interrogate the issues that each political party will bring forward and make sure that those things have merit. But there will be a certain room, I bet you.
For them going.
It will happen. And distortions and misrepresentations.
MPP propaganda.
Well, he says MPP, but I can tell you it will cut across the divide.
MPP propaganda.
You bet me. It will cut across the divide.
Okay, I'll bring you in here, Alhaji Yunus Afseni. Now,
Bad boy.
seeing what is coming up, he's been smeared with judgment debts, having a hand in the judgment debts, payments, and all of these matters. Do you find that you're going to have a difficulty, on your hands in how to properly project him for retention of power?
Well, I don't think that's going to be difficult at all. It has never been difficult for John Mahama to project John Mahama. Nobody in this country doubts the capability and capacity of John Mahama to rule this country. Nobody, even the MP.
He wasn't aware of the judgment debts.
No, but let me talk about it.
Felix, please hold it.
This is a person clearly. I mean, everybody knows.
It's not aware.
I mean, in the history of this country, there's only one president who has gone through the mill. There's only one, and he's John Mahama. He was member of parliament. He was there with Nana Kumia at the same time, 1996. He was spotted by the then President Rawlings and made a deputy minister.
They're talking about his track record.
Please, that's his track record. That is the track record of the man. That's his track record.
I don't get you.
He was,
in what sense? That he's the only one?
He's the only one
Others had experiences.
who has gone through the mill.
Dr. Liman was
the mill?
in the district council.
Let me finish it before.
So don't forget.
No, I'm not forgetting.
Let's finish
Let's
this
deal with
thing.
the
Let me
issues.
finish, and you will tell me that there has been a person like that.
You have very limited time, so focus.
I'm focused. So I'm talking about exposure. He was member of parliament. He was deputy minister. He was cabinet minister. He in parliament. He was shadow.
But is that the issue?
Ranking member of foreign affairs. He served in the AU parliament. He became a vice president, and he's not president.
No, is that the issue?
They are talking about his record as vice president.
His record as vice president. His record as vice president.
Stable
Yes, he
economy.
was part of the. He was part of the economic management team. Yes, but we got budget deficit standing at what percentage? 14 to 18%. If you add other debts, you get 18%. Today, what's the budget deficit? Less than 10%. This is the track record of the president. You got inflation. For so many years, MPP labored to bring inflation under control to a single digit. They never. They talk about the depreciation of the cedi. Let me tell you what happened in the MPP. This is Dr. Mahmoud Bawumia's book. Today, go to the Bank of Ghana. The cedi in 2008 to now has depreciated to 20%. 2008, the cedi depreciated by 20%. Look, I didn't say it. It's Dr. Mahmoud Bawumia who is saying.
What is the depreciation for this year?
For this year, 20%.
Is that right?
Go to
This year alone.
Go to the Bank of Ghana.
Yeah.
20%. This is Dr. Mahmoud Bawumia. Where have I put my? Yeah, it's here. That said, in an economy that seeks to
Which
be
page are you reading?
I'm reading his book, Monetary Policy and Financial Sector Reform in Africa, Ghana's Experience. Page 180. He gave, what the economy was doing. That said, in an economy that seeks to be export-driven, it is very important that policymakers continuously keep an eye on the real exchange rate list. A real appreciation makes Ghana's export uncompetitive. A real appreciation makes Ghana's exports uncompetitive. Inherent in that is admitting that the cedi will have to depreciate somehow.
You have a minute.
Now,
you have a
he says
minute. Do
that
it quick.
That was, however, There was, however,
Do you know
a
you have
20
oil revenues?
Please. There was,
Just
however, a 20.1%
revenues, right?
a 20.1% nominal depreciation of the cedi exchange rate
This
in
matter we have to come back
2008.
Let's come back.
The suggestion is that the major questions they are asking
The major question-
in respect of the
major question-
judgment debt and corruption and all
I'll come to all that.
cancel out
But
what
time-
you're talking
Coming to
about.
all
But
that.
the
Let-
corruption has not been proven.
That's why I'm not taking it from where Felix left off. I'm bringing out things about the NPP.
Exactly.
Now, this is the World Bank. This is Human Development Index. Ghana ranked 38 in human development. This is on Ghana web on Thursday, September 8, 2005.
Perception index.
Look at what they did during the years. All the money that came in Ghana, net aid increased from 3% of GDP in the mid-1990s to more than 7% in 2001 to 2003.
Okay, I understand that. Unfortunately, we are unable to continue. We should continue with this discussion next week. Next week, God willing. Thank you very much, gentlemen, for coming to the studio. This program has been produced by Sedem Ofori with assistance from Yahaya Abubakar, John Apia, and Emmanuel Ante. My name is Samson Ladia. Yanini is starting for Kojo Opon Nkrumah.